All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7129 et al. Oyoma, Asinor, and Brian Dozier, appellants versus District of Columbia et al. Mr. Perloff for the appellants, Ms. Coburn for the appellees.
Good morning, Council. Judge Henderson is with us. You can't see her, but she will be. Please proceed when you're ready.
Thank you, Your Honor, and good morning. Michael Perloff for plaintiffs' appellants, and may it please the court. I've reserved 2 minutes of my time. The Supreme Court has interpreted the Fourth Amendment seizure clause to apply to meaningful interferences with an individual's possessory interests in their property. One way the government can meaningfully interfere with someone's property is by taking possession. Prolonging the retention of property it previously took is another.
Can I just ask on that? What you say makes a lot of sense as an intuitive matter, but you do have a little bit of a textual problem. The Fourth Amendment governs seizures. The most natural understanding of the word seizure is it's something that happens quickly and then it's done. So how do you get over that problem?
Well, we appreciate Your Honor thinks our position makes sense. That's always a good start. As for the textual matter, we think that as a matter of text, our conception of seizure fits quite comfortably with the Fourth Amendment. And that's by looking back at the dictionary definitions of the word seizure from the time of the founding. We've cited several different dictionaries from the founding era, the same ones that the Supreme Court.
Johnson says take hold of, take possession, take forcible possession. That's a discrete act.
It also says possession, though, Your Honor, as does the dictionary from Webster. And the modern dictionary from Webster also says that the seizure encompasses the state of being seized, and it says that that definition traces back to the 15th century. So when we're looking at the word seizure, as it was understood at the time of the founding through today, it not only had the definition of taking of possession, which we recognize is relatively short-term act, but also had the definition of possession, which applies to the context that we're talking about. In addition to looking at the dictionary definition, we also look at the way that similar concepts existed at common law. And so we talk in our briefs about how at common law, property that was taken, even if it was lawfully taken, could still give rise to liability if the person who obtained possession failed to return it. Blackstone recognized that there were claims of detinue and trover, and various scholars have recognized that those claims could arise against federal officials. Indeed, there were cases that we cited where there were officers who actually seized property pursuant to writs of attachment. These are 19th century cases from state Supreme Courts that involved law enforcement officers seizing properties pursuant to writs of attachment and then being found liable for failing to give it back after the litigation succeeded in favor of the party who owned the property. I'd also refer the court to the historian's brief, which cites additional cases from the 1700s in parts D1 and 2 that endorse the same principle. So in terms of the text, we think when the text is read in a manner consistent with both dictionary definitions and history, it supports our definition, and also, quite frankly, common usage, Your Honor, because we can use seizure in a sentence to mean, for instance, he seized the purse snatcher. We can also use seizure in a sentence like we're using it here. For instance, the seizure of Miss Lynn lasted longer than its reasonable duration allowed. So as a matter of text, history, and common sense, we think our definition fits quite comfortably with what the Fourth Amendment permits. And it also fits well with precedent. And that's where I'd like to turn. So, Your Honor, there are several principles that come from the Supreme Court's decision in Jacobson through its application and interpretation of place, and that then were reaffirmed in Segura, that we believe are quite central to a resolution of this appeal. The first of those principles is that the seizure clause governs the manner of execution of property after possession is secured, even if possession is secured on probable cause. And the government—
Manner manner of execution might connote what happens during the relatively brief time when the seizure is effected. Feels a little bit different from the long-term possession question.
Your Honor, we know that manner of execution lasts beyond just the moments where the government is taking possession of the property, because Jacobson tells us that. In Jacobson, the court said that a seizure reasonable at its inception can become unreasonable based on its manner of execution. And
true, but citing place, which is just about the scope of a Terry seizure for property.
It's true that place is just about the Terry seizure for property, but Jacobson applies the reasoning of place to a seizure initiated on probable cause. And it says that the manner of execution can give rise to liability where the only issue with respect to the manner of execution in place was its length. So while we understand that place might not itself resolve this dispute, Jacobson's construction and application of place to circumstances that go well beyond its reasoning suggests that the Supreme Court understood and was attempting to take that rule and recognize that it spoke for something broader. And that approach that the court took in Jacobson, which they then affirmed in its approach in Segura, is also similar to what the courts have done in the criminal suppression context. So I would note there, Your Honor, that those courts, in holding that seizures lawfully initiated can become unreasonable because of a tardy warrant application, those cases rely on Jacobson. For instance, the Third Circuit's decision in Stable, Fourth Circuit's decision in Pratt. They also rely on place. Both of those decisions look to place as well. Again, even though the seizures were initiated on probable cause. And those cases also look to Segura, which the government discounts because it's a rule that came out of two different opinions. So what I think that indicates, Your Honor, is that these courts are interpreting place, Jacobson, and Segura to establish a broader constitutional principle, a constitutional principle that protects rights and possessory interests, and specifically the right that was at issue in all three of these cases, the ability to regain property after it was lawfully taken. And that's exactly how the criminal suppression cases explain their rule. Here's what the 11th Circuit said in Sparks, quote, "The purpose of the diligence requirement is to ensure that property thought to contain contraband can be returned promptly to its owners to limit the intrusion on their possessory interest should contraband not be found." That conception of the Fourth Amendment protecting the ability to get property back underlies what these other courts are doing and comports with Jacobson's definition of a seizure as encompassing a meaningful interference with possessory interests, and Sodal's conclusion that the Fourth Amendment's application turns not on the purpose of the officer, but rather on the intrusion in the possessory interests that the officer engages in. Now, I also want to return a bit to Your Honor's question about whether or not just this act of executing the seizure should be when it ends. Another point I think is that's important to keep in mind there is that many of the other cases outside the criminal suppression context have applied the Fourth Amendment, even though all meaningful actions in relation to the seizure have terminated. For instance, the district court's decision in Avila involved a claim that a seizure, though lawfully initiated, was unreasonably prolonged. And the court found that claim valid, even though the claim involved time that occurred, and the court counted time that occurred after a warrant had been secured and the property had been searched. Moms, Inc. from the Fourth Circuit involved another case involving a seizure occurring after a warrant had been obtained. And those 19th century common law cases that I mentioned earlier, both also found that liability could attach for interferences occurring after the acquisition of, after lawful process occurred in the form of enrichment.
Why no appeal on the Fifth Amendment?
Your Honor, we decided not to appeal the Fifth Amendment because we believe our fight isn't with the district court over its rules and its rules for processing property, but rather with MPD and over its procedures for handling the return of property. And rather, not in terms of its procedures, but the actual conduct and the way that it refuses to give property back. And I think Your Honor's question reflects an important distinction between the Fourth Amendment and the Fifth Amendment. The Fourth Amendment governs conduct. The Fifth Amendment governs process. The Fourth Amendment is directed towards law enforcement officers. It exists to ensure that law enforcement officers, when interacting with property, recognize the substantive rights that people have in their. The Fifth Amendment exists to speak to magistrates and legislatures to ensure that they provide adequate process so that when the government infringes rights, when law enforcement violate those sorts of rights that are secured by the Fourth Amendment, there's a backstop. Our issue in this case is with the first type of problem, the conduct of the law enforcement officers in failing to recognize the substantive rights protected in the concept of a seizure.
Are the remedies different?
The remedies may be different, Your Honor, in certain cases. For instance, in this matter, the court said that Rule 41G satisfies due process. All you get as a result of 41G is your phone back. Our clients, though, have additional injuries. They don't just need their phones back. They also deserve to be compensated for the time period that they were not able to use their phone.
And you're assuming the 41G process or whatever it might be in federal court would not include that remedy?
The 41G process that the district court looked to was the one in Superior Court. And we know.
Yeah, I know. Well, how does the federal court, what is your understanding? I'm sorry to sidetrack, but I'm trying to get this straight in my head. What is your understanding what the district court meant to say about the federal court's authority to be able to invoke 41G in a civil process, in a civil suit like this?
Your Honor, I'm not sure. I think that the
41G is a federal rule.
41G is a federal rule, but the district court was looking at the Superior Court's 41G. And the reason for that is that in a due process claim, federal procedural remedies are irrelevant. The question is whether the state has provided adequate procedural remedies. And so the district court looked to the federal case law on Rule 41G solely to understand the scope of the state rule, because it thought that the federal case law might shed light on that. But the federal practices aren't really dispositive of the Fifth Amendment claim. In any event, what I would note for Your Honor is that we know of no case holding that under the Superior Court rule, you can get damages for a prolonged seizure. And our understanding is that it's at least very highly questionable whether you could do that under the federal rule as well.
One last question, and we'll sidetrack you further. Is it your sense that you could have pushed on 41G in the federal court proceeding, in the civil proceeding, and said, look, whether we can get damages or not is another question. We want our property back?
Your Honor, I don't think we could have brought a 41G claim in this case because
Why?
that's a claim under the criminal rules. And so it would need to be on the criminal docket.
Interesting. Case law is very mixed, confusing on that. Okay, go ahead.
Yes, well, I think, Your Honor, the difficulty in figuring out the right vehicle from the 41G process reflects some of the challenges with that process for ordinary plaintiffs who may not have a criminal case against them and trying to figure out how they are supposed to proceed. That, I think, is the challenges of determining the right vehicle are indicative of that broader problem that many members of the DC community face, in large part because of this, what the district is doing with individuals' phones. I want to make one last point on the substance of our Fourth Amendment claim before turning to the municipal liability issue. And that's that looking back at overall what the government proposes, its vision of the Fourth Amendment doesn't make a lot of sense to the point we began talking about. It would hold that the Fourth Amendment applies if the government unreasonably keeps your cell phone for 90 minutes on reasonable suspicion, but not if it holds a phone seized incident to arrest for 3 years. It would hold that the Fourth Amendment applies if you have to wait, if the government waits a few days to secure a warrant, but not if it holds your phone for 3 years to force you to cooperate. It would say that the Fourth Amendment applies if the government intentionally nicks your phone, but not if it intentionally steals it. These outcomes don't make any sense. And precedent and history explain that they are inconsistent with what the Fourth Amendment is trying to do.
What do you do with Tate?
Tate, Your Honor?
Tate.
Yes.
Court's
court-
decision seems like probably the hardest one for you in my view.
Your Honor, Tate exclusively involves a seizure that the government had lawfully obtained title to. The court said that
They lawfully booted the car or towed the car or whatever. Right?
not just lawfully booted the car. The court also said that the court had the car had gone through the district's forfeiture procedures, and that was why there wasn't a takings claim, because the district had gained lawful title. So,
But when we came to the Fourth Amendment part of the analysis, we didn't say the car had been forfeited, so now it's government property, so no issue. we said that the government had lawfully possessed the car. So seizure over, I think we cited, don't hold me to this, I think we cited Hadari or Thompson or one of those cases that says seizure is a temporally limited event.
It was.
Your Honor,
It was Hodari.
Judge Henderson, you have a question?
No, I was just saying it was Hodari.
Right.
Your Honor, the decision in Tate, I think it's important to read in terms of its facts, and that certainly allows it to be harmonized with Jacobson and Place, which exclusively make, and Segura, which make clear that a seizure, that conduct occurring after possession is secured can in fact seizure. But I also would just say, and I know my time is up, but I would just say that Tate also poses problems for the government as well, if I may just make that point briefly. The government says that Jacobson applies to additional intrusions in property that convert the character of the initial seizure. It's hard to see how a sale of a car wouldn't be a Fourth Amendment violation under their theory as well. So we think when Tate's read in light of its facts, it doesn't pose an issue with Supreme Court precedent or our theory, but if it's read broader, it poses just as much a problem for them as for us. And I'll reserve the rest of my time. Thank you, Your Honor.
Judge Henderson, any questions?
No questions. Thank you.
Judge Edward?
I'm fine, thank you.
Okay, thanks. We'll give you some rebuttal. Ms. Coburn, good morning.
Morning, Your Honors. Thank you, and may it please the court. Marcella Coburn for the District of Columbia Appellees. Plaintiffs' cell phones were seized incident to their lawful arrests. No one disputes that the arrests and the seizures were lawful at the time the government took possession of the phones. The question instead is whether the government's continued possession of those phones is also a seizure under the Fourth Amendment. The answer is no, as 7 circuit courts agree. Instead, as those courts have held, and as the Supreme Court said in City of West Covina, the Due Process Clause governs procedures about return of personal property. Superior Court Rule 41G provides plaintiffs an adequate remedy to return of their property through the local courts. That is what the district court held, and plaintiffs do not challenge that ruling here on appeal. Instead, the Supreme Court has repeatedly held that the plain meaning of seizure as applied to personal property is a taking possession. It is a single act and not a continuous fact. That understanding was crucial to the holdings in the circuit courts. It's supported by founding era dictionaries, cases like Thompson versus Whitman, and this court's decision in Tate, which construed.
The problem is, I hear you, and you do have the circuits for the most part on your side, but both the district court and the government in this argument really are doing a bit of sleight of hand in reading what place means. The Supreme Court had a chance to follow up on that in Jacobson, and the district court focuses extensively on manner of execution. And that's it, and giving that a very limited view. That's not what the Supreme Court said. And the Supreme Court in Jacobson looked at that in footnote 25. It went on to say that in place, the court held that while the initial seizure of luggage for the purpose of subjecting it to a dog sniff test was reasonable, the seizure became unreasonable because its length unduly intruded upon constitutionally protected interests. So it is not accurate for you all to so straightforwardly say this is only about the initial taking period. Length does matter to the Supreme Court, at least so far as the Supreme Court thinks about it.
I think the Supreme Court in Jacobson did say that about place, and it's certainly true that length did matter in place. As we discussed in our brief, I think place is different. That's a seizure on something less than probable cause. And there the court said, when the seizure is on less than probable cause, we're going to impose a limitation on how long that seizure can be. But I think the other important language in Jacobson is at the beginning of section 3 of the court's opinion, where it describes the field test of the cocaine as a, quote, additional intrusion. And I think it's that additional intrusion, which is the one that the court says in the manner of execution changes the deprivation from a temporary one to a permanent one because it's a destruction of property. I think that's what the court is looking at as a seizure in that case.
If durational limit matters in the Terry context, where we're talking about minimal intrusion, plus or minus a little bit. Why in the world wouldn't it matter when we're talking about a seizure lasting months?
I actually think it makes sense, much more sense in that context, because the difference is between a seizure based on probable cause and a seizure based on something less. And I think the court in Terry and in Place was very focused on the idea that because the seizure is not based on probable cause and because there's no warrant, it wants to be very careful about the amount of intrusion
There's
the government can
probable
make.
cause on the front end. There's no continuing investigatory interest in these cell phones. You concede that.
I think that's right. But I think what the Supreme Court's cases say and what Thompson versus Whitman says is that the seizure is, except for in that Place context, a taking possession. And once that taking possession is complete, seizure is complete. So that the dictionary definitions that plaintiffs cite, when you get to the definition of seizure as possession, that's not till the 5th or 6th definition. All of the first ones are the act of seizing, the act of laying hold on, the act of taking possession.
Yeah, but that's not what Jacobson's description, and I don't know how you can just brush it off as if the words aren't there. The seizure became unreasonable because its length unduly intruded upon constitutionally protected interests. That has a very clear meaning to me. It may have been okay initially, but you're still holding this many months later for no reason. And the language in Jacobson describing Place seems to say the seizure now is the seizure. You are holding my property. It's still seized. Depends on how you look at the word seizure. You seized it and you're holding it, and that's part of the seizure. And if you continue to do it forever with no basis, you may have a Fourth Amendment problem.
I do think that's correct, but I think because Jacobson is talking about Place and because Place is talking about reasonable suspicion, I think what Jacobson means to say is what we agree with, that in Place, the duration is something that the court has to look at when it's assessing the reasonableness of a seizure.
Gee, that's not in the footnote.
I don't think so. It's not, Your Honor, but I think it's in Place. And I think the court's description of Place as a seizure based only on reasonable suspicion is clear. And when you look at Jacobson and what Jacobson itself decided, when Jacobson was looking at a seizure based on probable cause, it talked about the manner of execution of that seizure. And it talked about the additional intrusion that was occasioned by the destruction of the property in the field test. And of course, here we don't have a destruction of property. So I don't think Jacobson is a good analogy in this case.
You concede that the government has a legal obligation to return the cell phones, correct?
I think this court in the Wilson case did
Okay,
say
so
that. Yes.
if the Fourth Amendment doesn't apply, what is the source of that obligation? I mean, the due process clause just gives you process. You get the hearing to adjudicate some legal question.
That's
The
right.
legal question is, are they entitled to get the property back? What source of law gives them that entitlement?
I think what Wilson says is that it's fundamental to the integrity of the criminal justice process that the government ultimately is obligated to do their turn. That's right. But when you're talking about in terms of what the Constitution requires, I think it is the process has to be adequate. And of course, there could be common law claims or local claims against the district.
I'm sorry, to say that the Constitution requires some level of adjudicatory process to consider the question whether they get the cell phones back doesn't tell me what the source of the obligation is to return the cell phones.
I think that's right, Your Honor. Just to be clear, I agree with you that the constitutional due process clause provides the process obligation.
You either need substantive due process, which seems sort of goofy,
right?
Or maybe the takings clause, but there are all sorts of limits. Nobody briefed it, but there are all sorts of limits on, when a temporary intrusion is a taking. So
Yes.
if you just say no continuing interest, but we're just going to hold the phones for 2 extra months because we feel like it, I'm not sure that would be a taking.
I don't think it would be,
Okay,
Your
so
Honor.
then what compels you to give the phones back?
I think the answer there is once whatever the process is completed under Superior Court Rule 41G, the court has to decide, either, on the basis of the facts that are presented, either the government does have to return the phones or there's a reason that it doesn't. So I think the ultimate conclusion of the Rule 41G process is the court either says, government, your reasons aren't good enough, you got to return the phones, or it says you don't.
Okay.
And you think there's a money remedy that comes from 41G?
I think under the Superior Court Rule 41G, no. Now, if for some reason the court did not have an adequate process, of course, procedural due process
Well,
could
if
have a
there's no
damages
If
remedy.
there's no full remedy for your loss, and take the absurd cases like Judge Woods talked about in her separate opinion. This goes on and on and on. And the government has no explanation for why they continue to hold someone's property. None whatsoever.
I do think it's true that there's not a damages remedy under Rule 41, but I think the
So then
case is
what my
going.
colleague is asking you is, so you all seem to think there is a remedy and where is it? What's your source?
I think Rule 41G provides
But that's
constitutionally adequate remedy. And if there's no Rule 41G, you can get damages under the procedural due process clause. But since that is satisfied by Rule 41G, not available here. I would say, I think under the regime that plaintiffs want, there are a lot of costs too. The Sixth Circuit case in Fox says, under the rule that plaintiffs want, every unreasonable refusal to return property that followed a lawful initial seizure would constitute a Fourth Amendment violation. It would replace the well-developed procedural due process analysis that provides the states with the first chance to prevent possible constitutional wrongs with a new, uncertain Fourth Amendment analysis that allows litigants to jump straight to federal court every time a state official refuses to return property that was lawfully seized. And I think in those circumstances, that would apply not just to cases like this, but cases with abandoned property or cases where there's potential questionable or multiple claims. The court would have to assess the reasonableness of the government's effort to determine who owns the property in the first place. It would have to assess the reasonableness of the U.S. Attorney's Office decision about whether to prosecute individual cases. And where there's an adequate state law remedy under Rule 41G, don't think the Fourth Amendment doesn't apply for textual reasons, doesn't apply under this court's precedents, and there's no reason to interpose it when there's already these other remedies. And just to address some of the delayed search warrant cases that that plaintiffs discussed, those cases, I think the reason that those are Fourth Amendment cases is because, again, there is an additional Fourth Amendment intrusion there, and that's the search. And when the court, I think then Judge Gorsuch said this very clearly in the United States versus Christie case, where he said what we're looking at in these cases is the search and whether the search was reasonable. Now, of course, one of the factors that goes into that is the length of time the government has possessed the seized property. But just because that's a relevant factor to consider in terms of the search doesn't mean that it is a separate freestanding Fourth Amendment violation. Because again, the Fourth Amendment action in that case that's being assessed is the search. Similar to, I think, in Jacobson, where the Fourth Amendment action that the court is assessing is the additional intrusion caused by the seizure that changed the deprivation of property from temporary to permanent. That's an unreasonable seizure. And in the destruction or in the delayed search warrant cases, you have an unreasonable search. Here, you don't have that additional action at all. What you have is continuing possession. And possession, as the Thompson versus Whitman case, that's a case about the ship in New Jersey. That case says possession, which follows seizure, is not the same thing. The seizure is a single act, not a continuous act.
True. And Thompson helps you with your argument about the most natural reading of seizure, but that's not Fourth Amendment law. And I mean, the one thing we know for sure in the Fourth Amendment context is that the word seizure doesn't prevent ongoing Fourth Amendment scrutiny when we're talking about seizure of a person, right?
That's right.
Pretrial detention. Okay,
Yes.
so what's the textual or structural basis for saying the word seizure has this ongoing connotation when the government has possession of a person, but not when it has possession of personality effects?
I think two things to say to that. The first thing is, you're right, Thompson, not a Fourth Amendment case. the court did rely on it for the definition of seizure in both Hodari D and Torres. So I think that's relevant. And with respect to the seizure of persons, I think Torres gives us the answer, because Torres says that the character of the thing being seized can affect the meaning of the seizure.
It says that on the front end of the seizure to explain why we don't require possession, because you have all these line drawing problems with the fleeing or struggling suspect. Arguably, it, maybe reading between the lines, it says that because people want a remedy for someone who gets shot, but that's just a different question.
Well, here's how I think.
Why would we distinguish on the back end just because we have to distinguish on the front end?
Here's how I think it's consistent with the whole definition that we're proposing. Because in the seizure of persons cases, there is, in some cases, a continuing seizure because of the person's liberty interests, because their free will, because they want to leave custody. So what the government has to continually do is to continually take possession of the person to prevent them from leaving, either by exerting force on them or by a show of authority that the person then yields to. So I think you can view it as a moment of many continuing taking possessions of a person. That analysis doesn't make any sense with respect to property, because once I take possession of the property, I don't need to continue exerting any force on it.
I mean, sure, the cell phone can't walk off by itself, but the lawyers are making phone calls saying, give us the cell phone back. If the clients tried to walk in the station and get the cell phones, they'd be physically restrained.
They certainly can. I think the physical restraint of the person coming in to get the cell phone may be a seizure of that person, but I don't think it.
But there is a continuing application of force. It's just less obvious for the personality.
I'm not sure that that's right, Your Honor, because I think because with the seizure of persons, it can also be yielding to a show of authority and the application of force with the intent to restrain. That's another important part of that. And I don't think either of those things apply to what you're doing with a cell phone when you're keeping it in your possession. I don't think, even if I set the phone down on the table, I don't think we can say in the moments that follow, I am applying force to it with any intent to restrain it. I am just possessing it. And so I think that's the basis of the decision in the case about the ship. I think that is what the court says. It uses the taking possession definition from Hodari D in the Tate case. And I think that is the understanding of seizure that the Supreme Court has put forward, the other circuit courts have adopted with respect to seizures of personal property.
That line, it's interesting, the line of argument you just advanced isn't completely right. It becomes a little philosophical almost when you think it through. You are exercising control over a person, especially when you use cell phone as the example. That person can argue, my existence is in that thing. I mean, there are a lot of people walking around out there, you don't think they have an existence beyond their phone. And you take it away, they're lost. They can't find anything, they can't do anything, they can't communicate any longer, and you might just as well restrain them bodily. So, I mean, I think you're overstating it to say they're not comparable situations.
We of course understand and think that cell phones are very important to people's daily life and to modern society. But I think that the line that's drawn in the Torres case is about the liberty interest of the thing that is being restrained. And I think in this case, you just can't say, I think it would be an overreading of those cases to say that just because cell phones are really important, that they have a comparable liberty interest, free will, and desire to leave.
There are a lot of teenagers who would argue with you and say
I'm sure there are.
The liberty interest has been restrained if you take their cell phone.
I'm sure that's right, Your Honor. The other thing I would mention, I think, is we're talking about 19th century cases and the potential remedy in those cases. Justice O'Connor's concurrence, she points out in the Hudson versus Palmer case, that just because those causes of action existed at the time of the founding doesn't mean they were incorporated into the word seizure. That's also in the Supreme Court's recent Wyoming case.
I'm not sure what year the opinion you're referencing was. I mean, there have been a lot of Fourth Amendment cases in the last 10 years linking Fourth Amendment at a minimum to common law property.
I think that is certainly
right.
That is certainly right. But I think it can't override the consistent, repeatedly applied definition that the Supreme Court has reflected in the founding dictionaries that say that the seizure is a taking possession. Yes, that a seizure is a taking possession. And so, I think with all that said, and I know my time is running out. And so I would just say, I think under plaintiff's rule, what ends up happening is that instead of these cases being taken care of in local court under Rule 41G, you have an influx of cases that can be brought again every 2 weeks about abandoned property, about property the U.S. Attorney's Office is deciding what to do with. And that's just not required by the Fourth Amendment. Thank you, Your Honor.
Judge Henderson, any questions?
No, thank you.
Thank you.
Thank you. We'll give you 2 minutes.
Thank you, Your Honor. Just a few points to clear up. First, returning to Tate, I think that, as I said before, it's important to read that case in light of the broader context in which it was written, involving not just a taking of possession, but a taking of title. And that makes sense because it allows the court's decision in Tate to comport with what this court has recognized, which is that Hodari doesn't tell the whole story of the Fourth Amendment. The Fourth Amendment continues to address what happens after possession has been secured. Indeed, in Tate, duration wasn't challenged. It was about the sale, which is a distinct issue than what's been presented here. I think I would also note, as you said, Judge Katsas, that the person cases are quite important. And my friends on the other side try to turn these cases into hinging on the need to continually restrain someone. But that wasn't what was going on in Barnett, where the person was just put into a cell. It wasn't the problem that the person was being restrained over and over. It was the overall interference with their liberty interest. And indeed, going to what Judge Edwards was saying, the Supreme Court has set in place that taking someone's property and not telling them how to get it back indeed can infringe with their liberty, regardless of the context in which it occurs. Additionally, on Jacobson shows, as Judge Edwards was saying, that Hodari doesn't tell the whole story, that the Fourth Amendment goes to length. I'd like also to talk briefly about the Fourth Amendment, Fifth Amendment issue that we touched on in the prior conversation. The fact that both amendments may be relevant is not necessarily a crucial fact in this case, because as the Supreme Court has said, the burden on lower courts is to decide whether each amendment applies, not the precise line between them. Finally, a word on practicalities. The government says that our position will result in lots and lots of litigation, but we haven't seen a deluge of lawsuits in the Ninth Circuit, the largest circuit in the country where this rule applies. And the reason we haven't seen that is because when the Ninth Circuit clarified the Fourth Amendment law, the government obeyed it. And we also haven't seen it because this test isn't about whether the Fourth Amendment is violated by what the police do. Rather, it's just if the Fourth Amendment applies. And as the Supreme Court said in Soldal, the ultimate touchstone is reasonableness. Unreasonable conduct, even long conduct, may well be reasonable if it's justified by the government's interest as compared to the possessory interest of the individual. And so because of that, we think courts are perfectly capable of recognizing that and weeding out problematic.
I take your point that claimants might not always win, but there will very often be litigable issues about reasonableness. So shouldn't we worry about that as well?
First off, Your Honor, the Supreme Court recognized that risk, but that didn't stop it from holding in Soldal that the Fourth Amendment applies well outside the criminal code. Additionally, most of the time when the government takes property, it does so where there's a pending criminal case. And in those scenarios, the sorts of confusions that I was discussing with Judge Edwards about whether 41G applies don't arise. But outside that context, where someone has to hire a lawyer to represent them for a very low damages case, that isn't going to be something that most people will be able to do in 41G, but it might arise where there's a Fourth Amendment remedy that can help people address this. Thank you, Your Honor.
Judge Henderson, any questions?
No, thank you.
Thanks to both counsel for your very helpful arguments. The case is submitted.
Is there an IT person from the court here? If so, can you please come up? No, I can't. Watching what you're doing. Uh, What? So what did you do? You hit what?
Chat.
Chat, I did that. I did chat. And then where did you go from chat?
Just.
You just went to search button from chat?
I mean, not just.
So you hit chat and then you,
People didn't see that. But now I can do.
yeah, no, okay. All right, 18. It was not a solution, just don't use it.
Case number
Sorry.
22-1163 et al. Hospital Menonita de Guayama, Inc. Petitioner versus National Labor Relations Board. Mr. Muldowney for the petitioner, Ms. Beard for the respondent.
Good morning, Your Honor.
Muldowney is,
Muldowney, yes, Your
good
Honor.
morning, please proceed.
Thank you, Your Honor. If it pleases the court, Patrick Muldowney on behalf of the petitioner, Hospital Menonita. This case involves the application of the successor bar under the National Labor Relations Act. In this case, the board applied the most recent iteration of the successor bar adopted in the UGL Unico case, which purported to make what was previously a rebuttable presumption of union majority status irrebuttable during a successorship issue. Relying on that case, the board concluded that the petitioner had unlawfully withdrew recognition from the union. We recite the factual background in our brief, but just briefly, the petitioner acquired a hospital in.
We know the basic
Yeah,
facts.
okay.
So can I just
Just-
ask on that?
Sure.
The textual hook for your argument is section 7 of the act, which says basically that employees have a right to associate or dissociate with union through elections, right?
Correct.
I mean, just in ordinary meaning, you wouldn't think of that right as being burdened or infringed or violated if the scheme provided for periodic but not continuous elections. No one thinks that the public's right to select our president is burdened because we only do it once every 4 years.
Correct, Your Honor. And before I answer your question and discuss this with you, I did reserve 3 minutes for rebuttal.
Fine, well,
But in this situation, this is the very case that really, I would argue, looks to assert the rebuttable presumption, that the rebuttable presumption is correct. Because when you look at the situation here, the employees had been represented by a union for a number of years before the petitioner acquired the hospital. And during that time, during the at least 4 years prior to the acquisition of the hospital, the employees had not received the contract. Had not received the contract. There had been no contract negotiated, including for 2 particular units of the 5 units that were there that had been initially recognized in 2012. They never got an agreement. So this is.
You mean an agreement was never negotiated?
Correct.
By their representative? You're stating it in a very self-serving way, but that's not what goes on. Parties sometimes break down in negotiations, but the employees are still represented. And
However,
benefits are still paid, and they can't be implemented unilaterally when the union is there. The negotiation process is still there and in effect. The fact that the parties are still struggling over executing a particular contract doesn't mean the employees are not represented. They are.
But what happened with respect to the petitioner came into this situation and eventually received petition signed by the majority of each of the 5 units of employees saying, we do not want to be represented by the union because they had been in this situation where the union had been ineffectual. What the board's, the whole idea of the successorship bar or the successorship presumption is the idea that the successor comes into the relationship and is then assuming the predecessor's relationship with the union. In this situation, there was no relationship. There was
a relationship, but it wasn't as you thought it might exist because it wasn't an executed agreement. There was a relationship. That's why the rule is what it is. The presumption is there is a relationship. The presumption is you have an obligation to bargain for a reasonable period of time. It's not a long period, reasonable period of time. And the only difference, old and new, is whether it's rebuttable or not. And and the board explained it in the prior case as to why they take this approach. It's a perfectly reasonable approach. Certainly not one we ought to second guess. They've explained it. It's for a short, reasonable period of time. They said in this situation, the union, the employer, your client failed to follow the rule.
Your Honor, what we take exception with the board on is that the irrebuttable nature of it basically makes these employees who may not want to continue to be represented.
Well, in 6 months, then it'll play out that way.
It could be 6 months.
If you read the record, your client was buying all of that time anyway by being resistant to any overtures for bargaining and bargaining obligations. 6 months is not a long period of time. There's an obligation to bargain for 6 months up to a year under the existing rule. It's not rebuttable, that's true, but the question is whether there is a rationale supporting the rule. It seems to me there is, and the board has explained it.
Well, we would submit that the rationale that the board submitted in the UGL case was basically that, gee, there had been a large increase in mergers and acquisition. There's no tie of that to unionized employment places or any kind of indication that in the years since the rebuttable presumption had been resurrected after the back and forth, that there had been any increase in either decert petitions or ULP cases involving withdrawal of recognition. So while there's a general statement by the board, well, gee, this has happened, there's no connection of that to how it serves the purposes of the act.
I don't think that's the main rationale. The main rationale of the board, as I remember what they said, both in this case and in the original case setting the groundwork for this, is that you don't disturb employees' settled rights merely because a successor comes in without requiring the successor to at least bargain for a reasonable period of time, knowing that a union is there, a reasonable period of time, and then if it doesn't work out, that's a different issue. That's the rationale. I mean, there are other things that are said justifying it, but that's the main point. And as my colleague mentioned, that is consistent with protecting the rights of employees. And it's hardly burdensome on employers because it's not, you must bargain forever. It's for a reasonable period of time because there's already a union here. And you bought the place knowing there was a union here.
And based on the record, they were ready to negotiate with them.
Well, then that's a different question. And the board's answer to you on that one, I suspect, is that substantial evidence supports their finding that they were not ready to bargain the way they were obliged to.
I'm sorry, Your Honor,
I'm sorry. The board is going to say the substantial evidence supports their finding that the employer was not ready to bargain as the law required.
But we would argue
that's a substantial evidence standard of review.
And a considerable portion of that claim in terms of the failure to bargain comes out of post-withdrawal actions by the petitioner. And again, based upon the information that petitioner had received, that was objective from a majority of each of the units as they withdrew recognition because under Section 7 provides for the board, under the Act that that employees have the right to engage in bargaining or the right to refrain from doing it in terms of collective bargaining. And what the irrebuttable presumption, with all due respect to the board, what that creates is it translates the rights of employees under Section 7 into a union security clause. And that's not what the act is supposed to be.
I just don't see how that follows. You've got someone who comes in, buys an operation with a union, knowing that the rule is if you're a successor where there is a union under established law, you have to bargain in good faith for a reasonable period of time, 6 months to a year. 6 months is an insignificant period of time. And that's what the board was essentially saying. It protects the rights because employees are now in flux because there's a new employer. And so the least that they're entitled to is good faith bargaining for a reasonable period of time. If it doesn't work out, it doesn't work out.
But Your Honor, given the factual situation here, that you have at best a dysfunctional union relationship with their own members. The issue here in terms of whether they have to automatically recognize the union for 6 months to a year in the face of objective evidence, which the ALJ wouldn't look at because of the irrebuttable presumption. When you've got that issue there, the board should have to at least consider that issue before finding that there was an unfair labor practice by not negotiating with the union after they had received the objective evidence of failure of desire not to be represented by that union.
Can you give us any sense outside the successorship context, just in the ordinary course, how often is a recognized union challenged through one of these various mechanisms?
I mean, in terms of the majority status?
Yeah.
I mean, it is not a common occurrence. I mean, it's not a common occurrence. I mean, all I can give you is sort of my anecdotal experience.
Yeah, just sort of ballpark, right? I mean, it doesn't typically happen every few months.
Right. It is not a standard part of my practice, nor has it ever been. And I think most labor attorneys on the management side would agree with that.
So if that's true, then there's a lot of force to Judge Edwards' point that 6 months to a year is not a huge infringement on the employee's Section 7 rights.
Well, I would say the opposite. I would say that because it doesn't happen very often, it really shows that the employees themselves have an issue, and that in terms of their representation by the union and their Section 7 rights should be paramount. And by requiring them to continue to be in the successor position, after they've been represented by this union already over the course of 4 or 5 or more years, is unfair to the employee.
Did they file a decert petition before the successor came in?
I don't have that information.
Well, I mean, isn't that relevant? Then obviously the employees were not so distressed that before the successor came in, they were filing a decert to get out of the existing relationship. They weren't that dysfunctional, apparently. So, I mean, they're in the same situation they were in before the successor came in. They were in a bargaining relationship. If they wanted to get out of it, they could, at the appropriate time, file a decertification petition. They hadn't done that. So all that happened was a new owner came in, and the new owner had the same obligation as the old owner to bargain in good faith. And it's limited because it is a successor, and the board has said, no, you don't have to bargain in good faith forever. We're not going to assume there's a majority support for you forever. You have to do it for a reasonable period of time. And if it doesn't work, then you can fly the coop.
But Your Honor, again, what they may have done prior to the sale, the fact of the matter is when the petitioner came in, they ultimately were confronted with this evidence that they were given. And given that evidence, we would argue that the Section 7 rights should be paramount.
Well, that's because you want a different rule. You want to be able to say there's a rebuttable presumption which really makes the situation dysfunctional if you understand what goes on when employees, the union, pro-union, anti-union are now fighting about whether or not anyone represents them. And that may go on for a lot longer than the 6 months to a year before you ever get that resolved. So, I mean, what the board is saying, look, all things considered, yes, it's employees' rights that have to be protected. We're not disturbing those rights because they already had a union and they hadn't done anything to get rid of the union. There's only thing that's happened is a new employer. And we're saying to new employers, you're on notice. You got to bargain for 6 months to a year, reasonably. And then if it doesn't work out, then it's a different situation.
But
And I also think we need to look at the timing of these petitions, because if they were happening at the same time the new employer was handing out cash payments and other things,
Right.
I'm not so sure that those petitions to get rid of the union aren't a little tainted by that.
Right.
Or
Again,
influenced anyway.
Well, we don't, the issue about, I take it, Your Honor, you're talking about the hurricane bonus, the $150.
Well, all the goodies that were suddenly coming.
Right.
Because the employer was doing, I mean, years and years and years ago, I used to do this. I mean, I know the situation. And employers are doing everything they can now to try and win this battle. That is not to have a union when this is all over. And so it's a little here and a little there. And what the board rule says is, no, we're going to have a little repose during a period of time when you have to bargain in good faith. And then if it doesn't work, that's another issue.
But what's interesting, Your Honor, though, is that the board previously had the rebuttable presumption.
I understand.
And they went back and forth as.
You know as well as I do, you may not be as old as I am, but you're old enough to know the board changes substantive policy determinations all the time.
I understand.
In my
Your Honor.
lifetime, they've probably done it, 20,000 times? I mean, and we have said it's their job, they can take into account circumstances as they see them.
Point well taken, Your Honor, but I would suggest
That
though.
you're as old as I am?
I may be after this hearing, I don't know. Your Honor, I would take one issue with respect to the certification, the rebuttable versus irrebuttable presumption. Again, when the board went back on to the irrebuttable presumption, the only rationale was this mergers and acquisitions argument, which did not connect in any way to labor. They said, oh, there's a lot of mergers and acquisitions. And looking at the Lilly Transportation case that the First Circuit had dealt with, Justice Souter said he kind of tried to fill in what he called the laconic exercise of the board in terms of providing a rationale for why they were changing it. But his was basically a workload. He said, well, there are going to be a lot of cases coming in, but
What's wrong with Justice Souter's core reasoning, right? Which is you can't extract from the words of Section 7 a bright line rule about when elections have to happen or not. 10 years, clearly too much. 2 weeks, clearly okay. And so the board is exercising discretion in balancing the degree of intrusion onto the Section 7 interest with a lot of other competing interests about stability and such. And that question is we just review their balancing as a matter under the arbitrary and capricious standard, and that's all we do.
well, I would argue, Your Honor, that that a lot of what you had mentioned was sort of procedural in nature in terms of the timing of elections and things like that. This is substantive. And we would argue, because it's dealing with our view, depriving the employees of their Section 7 rights, because they have expressed their desire not to be in the union.
I don't know if it's procedural or substantive. The point is there's no judicially discernible timeline when elections have to happen.
that is true.
We can't stare at the text and say, oh, it has to be every 4 years or every 2 years or every 1 year.
You're in terms of talking about changing
When,
majority status.
right, correct.
Well, but again, whether it's every 2 years, 4 years, et cetera, what we had in this case is we received those petitions at the time we received them. So whether it's whenever the timeframe for doing an election, we were confronted with expressions by the employees that they no longer wish to be represented by that union and wanted to deal with petitioner directly.
I mean, you keep trying to talk about the facts of your case. I'm not sure they're helpful to you, but I'm just asking you about the bright line rule. I mean, generally agencies can just draw lines and say, like, you know, we'll mandate a reconsideration every 2 years just to make sure, or we'll prohibit a reconsideration within a year of an election because the union needs some time to do its thing.
Again, that you're talking about the certification bar, and in that one, we're not, you know, that's a new relationship where the union is just coming in. This is a relationship that's been existing for some time. So the concerns and the policy issues behind the certification bar don't apply here in the successor bar. And again, we're not arguing there shouldn't be a rule. What we're arguing is that there needs to be possibility that that rule should not be as bright line in these kinds of circumstances, because you have people coming into different working environments, in terms of the relationship between the union and
they've established a rule. You're advocating. What rule are you advocating?
Going back to the rebuttable presumption.
Right. So they can never. They can't establish a bar for a month.
That if there's sufficient evidence that would justify removing the bar, they should be able to consider it.
Okay. Judge Henderson, any other questions?
I don't have a question, but I would like the record to reflect that Judge Edwards is not that old. I am right behind him.
Thank you. Thank you, Judge.
And I'm right behind both of you, Your Honors. Thank you.
Anything else? Okay, thank you. We'll hear from the board. Ms. Beard.
Yes, good morning. Heather Beard from the Labor Board. As the board said, and as Your Honors were discussing, the facts here in this case provide support and make it crystal clear why the protection of a successor bar is reasonable for the board to have as a rule and appropriately balances the rights of employees under Section 7 and the interest in stability and collective bargaining relationships, which itself is a precept for employee rights. And I believe there are a few points I'd like to address first that my opponent made, if I may. The first one is in regards to the fact that they received this petition from the employees. Said that many times. The law has been clear since 2011, which is any such petition received from employees during this reasonable period of time, which is at least 6 months, is something that cannot be considered by the employer. So it isn't like we have a case here where the employer didn't know what the law was. That's number one. Number two, this situation where my friend on the other side is saying that the hospital came in and knows now that the employees had a dysfunctional relationship because they didn't have a bargaining agreement, as Judge Edwards said, is simply, we don't know that from the record and is absolutely not necessarily true. What we do know is that the employees had voted for and had a union in all 5 units and collective bargaining agreements in 3 that had expired, whose terms and conditions of employment were the ones that govern. We know.
Let's just take a step back from the facts and just talk about the successor bar. So what is it about the change in ownership that moves the needle one way or the other on the question whether the employees support their union?
Sure. Well, because
seems totally different from the most conventional bar, which is triggered by certification.
Or a contract bar, that's another one.
Contract, well, actually, a question about that. The contract bar, does that apply in cases where the employees don't ratify the contract, or only in cases when they do?
Well, if the employees don't ratify the contract, then my understanding is the contract doesn't apply. Because it would have to be the employees have to ratify a contract that the union is signing, I think.
I couldn't find any. So if that's how it works, then the contract bar and the certification bar are triggered by events that affirmatively indicate support by the employees of the union.
When the union is certified, the law as it is, the board law is that the union is the collective bargaining exclusive of the employees.
For 1 year, conclusive, makes perfect sense because the board has just made that determination.
And that's in the statute, yes.
Okay, but when the owners change, what does that have to do with whether the employees support the union or not?
A lot to do with it because they're the bargaining partner on the other side of the union and the terms and conditions of employment. This case was one of them where the employer who's new comes in and decides that as they don't have to accept any collective bargaining agreement that's there, but they have to bargain. And in this case, what they also did is they changed the terms and conditions of employment that all the employees were used to working under when they had their union and under the terms of the 3 bargaining units who had the collective bargaining agreements that were in place that had expired, but whose terms would have been the same. So when you have a new bargaining partner coming in, a new bargaining partner, especially here, that changed the terms and conditions of
they can unilaterally change.
Yes, under
Burns says that if there were no successorship, status quo ante, the employer could not unilaterally change?
Correct. That's black letter board law. No unilateral changes when they're in terms and conditions of employment without discussing with the union.
Okay.
Yes. So in this particular case, that is why the board, when considering when a new employer comes in, and this goes back to Fall River dying, when a new employer comes in, that's one of the most destabilizing situations you can have because this new employer is new. And so here, and in other cases, when a new employer comes in, what the board was doing is saying, what's the best way, and the board is the expert agency doing this, that we can balance the rights of the employees and in order to keep, I mean, it's throughout Supreme Court and other case law that in order for there to be stability during a collective bargaining relationship, there has to be some amount of time that it's set to continue. As you all were talking about the presidential election, various elections, it's not new to have some limited period of time where there isn't an election. And the key here is the board did not find for 10 years you can't decertify or file a petition for certification. Simply 6 months from
the 6 months seems to me clearly reasonable for reasons Judge Edwards suggests.
I agree.
But I'm a little concerned with, and I think the dissent made this point, the interaction between the successor bar and the contract bar. So you imagine the contract bar gives the union 3 years of protection before successorship. Then the successor bar attaches, gives them another year within which they execute another contract, which would have given them 3 more years. That's 7. The board said, oh, 7 sounds long. We'll make it 6. 6 or 7 is really long. That's a huge burden on employee rights to choose their union.
I would respectfully disagree with that. I would say that when the board did go, it wasn't insignificant when the board considered, exactly as you said, how there might be a possibility of a length of bars like that. However, if there was a contract bar following the employer bargaining with the union and coming up with a contract. And I think that the way that they did decide that, even though that is speculative, that they were shortening the amount of time from 3 years to 2 years, is pretty significant in the board looking at the facts and some of the counter arguments and coming up with what was reasonable and certainly has not been, I would point out, my opponent has not challenged that.
I can't remember. Did they reserve the possibility of an as-applied challenge under Section 7 in a scenario like that? Because you're right, the 312 won't always arise, but it might. Is that an open question or no?
I guess, I'm sorry, Your Honor, I don't understand your question. Can you repeat it?
The board approved a general rule of a year, 6 months or a year, which could latch on to the 3 years in pre-succession, 2 years post-succession.
Okay.
If you have that perfect storm of restricting employee rights, what happens in that specific case?
Right. So, first of all, I respectfully disagree that that's restricting employee rights.
I got it.
Okay. But beyond that, I would say, no, the board is saying, should that happen, that would be okay under its successor bar, that there would be the 3.
Right. So so you have a rule that in some applications seems pretty modest. In others, just for the sake of argument, just assume is pretty draconian.
Sure, well, it could be, it could be. I mean, the thing that we're also not putting in that calculus of speculation, respectfully, is the fact that if the employer comes in and like it didn't do here and bargains, which is its obligation, that 6 months goes by pretty quickly. If it bargains on, in this particular instance, we don't have that as applied challenge that you're talking about. I mean, not only was that not raised by my opponent, it's something that in this instance is, we're sort of in the very, very key and easy case where you have an employer that comes in and as, substantial evidence supports on this record does not fulfill its bargaining obligation with the union. You then have, you would have to see that this was a case where, as the board said, and, why it, the board gave one of its extraordinary remedies here, which is it said, look, this bargaining relationship did not have any chance to succeed under this. So here what you had is the employee's rights in the equation really.
Yeah, the facts here are pretty good for you. I'm worried about how the rule might apply.
Right.
Let me make sure we're on the same page. Using this situation, union comes in, they have an obligation to bargain. I mean, the employer has an obligation to bargain for 6 months or so. And they bargain in good faith. They reach no agreement. What are the rights of the employees?
And they reached no agreement?
No agreement.
Right. Okay. So if under the successor bar, they've bargained, 6 months has gone by.
Right.
The general counsel then, in order to claim there's any sort of unfair labor practice with regard to
Just answer my question. What are the employees' rights in that situation? No agreement is reached.
No.
It was good faith bargaining.
And there's an impasse,
Can
then the employees,
can
ostensibly, yes, the employees can file a decertification
Exactly.
petition.
I mean, we're walking around one obvious answer to the expressed concern by counsel on the other side. The employees are not locked in. The period is minimal. They don't reach an agreement, and they can't reach an agreement if the employees don't agree. So if the employees hate this union, they're not going to buy anything the union does. And at the end of the 6 month period, say, no, we're not ratifying anything you put on the table, and we're going to file a decert petition, right?
Yes.
Okay. So, I mean, that's the answer to the other side. Just be honest, do what the law requires, because it may be protecting employees' interests. And if it doesn't work out, the employees' interests will now come to the fore because they're going to say, we're going to get out from under this union.
Right. I mean, that's exactly right.
There's no contract bar or any other bar that prevents employees from walking away after 6 months.
As long as that was a reasonable period, right? As long as that was a period of time, absolutely. So the board's balancing here that it did is incredibly common for what the board does and why it is considered the expert on labor law. I do want to speak to the mergers and acquisitions point, though, that my opponent raised in terms of like, that's the only reason this is happening. I would agree. In back reading UGL Unico, that was one consideration where the majority made the point, which I think is an excellent one. The fact that there are mergers and acquisitions that are taking place at a faster and faster pace simply demonstrates it's really important to get this right. It's really important. Back in UGL Unico, they were changing what the law was and explaining why they were doing it and why they thought rebuttable presumption wasn't adequate. And now we've had that law. We're not up here justifying the board changing a rule recently. We're up here talking about a rule that the board has had in place after it had made a policy decision to change it back. And
Court had already justified
yes,
in the prior case. And in the current case, they were simply saying our prior justification is the same one we'd offer here. It
correct.
wasn't just mergers and acquisitions are the reason we're not going to flip again. The mergers and acquisition had come up in the prior case, right?
That's correct. And so in
They
this,
focused on was stability. Again, they
Yes.
said, look, this is about stability for the employees. It's a destabilizing period. It's a very short period of time to make sure they have a chance to bargain in a potentially destabilizing period. And if it doesn't work out, it doesn't work out.
absolutely, I agree, Judge Edwards. And as Judge Henderson was saying as well, I mean, we can see how this could sort of be a destabilizing period where we're not sure what's going to happen or how the employees really feel when the employer came in and the new employer did make a bunch of unilateral changes that were could be considered favorable to the employees. So this sort of is a poster child for a reasonable application of the successor bar and further buttresses the reasoning in UGL Unico that the board did in terms of why this is the policy choice that the board thinks best fulfills the rights of all the parties involved.
Can I ask you a question about Burns?
Sure.
So the second holding of Burns, which is that the successor is not bound to accept the agreement of the predecessor. Court says the alternative position of compelled acceptance would cause a loss. And then it has this reductio. And part of the reductio is the court says, among these problems, the successor would be bound to observe the contract despite good faith doubts about the union's majority during the time
Right.
the contract bar. So it seems like, what Burns views as a reductio is what the board now views as great policy.
Well, I would say it's a very different thing to talk about binding a new employer to a contract that it has not signed versus saying to a new employer coming in who knows it's buying a company that has a union there, you're going to have to at least talk to these people. You're going to have to bargain.
I take that point, except the court seemed to link the two.
In Burns, though, I think they were talking about having the employer bound to the contract. And nothing in Burns says that a period of time with a conclusive presumption like the one the board has adopted is in any way unlawful. And in fact, I think Burns does focus on the problem with making an employer adopt the contract, which this successor bar rule doesn't do, doesn't get involved in the reductio at all, I would say.
No, it does. It's not applicable.
Correct.
That's not the situation.
Right, nor is it something that even if it wasn't this factual situation broadly, generally for Judge Katsas' question for policy, no, there's nothing about, as former Associate Justice Souter said in Lilly, there's nothing about Burns or Fall River Dying for that matter in any way that conflicts with what the board's doing. And I see my time has expired.
Judge Henderson, anything else?
No questions.
Okay, thank you very much.
Thank you.
Give you 2 minutes.
Thank you, Your Honor. Just a couple of points to address with respect to my colleague here. First of all, I just want to make sure it's clear that I thought there was some confusion in the prior colloquy. Obviously, a successor employer's responsibility is to bargain with the union. It's not to agree to the contract, and just make sure that's clear that.
No confusion.
We know.
Okay,
No
good.
confusion.
Okay, I did sound
No
like.
confusion
Okay,
whatsoever.
but I would indicate though, Your Honor, that in those cases.
Bargain in good faith.
What's that?
Bargain in good faith. That's the obligation.
We agree on that too,
Yeah,
Your Honor.
exactly.
We
Okay.
agree on good bargaining in good faith. But Your Honor, we would argue that when you look at Falls River in particular, Falls River, while that was they referenced the existing NLRB test at that time, which was the rebuttable presumption. when they talked about, when they were dealing with successorship issues. And they did not criticize it. Now, again, it wasn't necessarily right before them, but one would expect that there would have been at least something, if they had a concern with it, that they would have raised about that issue. Also, with respect to in the Burns case, Justice White did make a comment with respect to the successorship issues in front of him, that these cases needed to be decided on a case-by-case basis. We would argue that this is a similar situation when there's evidence to suggest that the bar should not be applied. The board should be able to have to consider it, that's part of their responsibility as an agency that's adjudicating the rights of employees to adjudicate issues that come up that may be an exception to the general rule. And again, that was sort of where that's where the board was before the most recent change in the law. And then also I would just indicate the timeline here is the petitioner acquired the hospital in September. The changes, the withdrawals of recognition were in February. So we're talking pretty close to 6 months as it is. And so to the extent that the board wants to create a bright line rule there, the bright line rule, I think betrays the idea that there are facts that exceptions that would prove that there should be consideration of an exception to the rule. And then lastly, I would argue again to my colleague's point that there is no connection. The board never connected the mergers and acquisitions to any kind of stability issue with respect to labor relations. They just indicated that there's been a lot of mergers and acquisitions, but there's no connection to labor relations.
Henderson, any questions?
No.
Okay, thank you.
Thank you, Your Honor.
Case is submitted.